figured if we can squeeze in the hour, now is when we got to start. For all of us, I think we all know Steve, but I would like to introduce Steve, who will be talking about the street-level guide to the Fourth Amendment. There will be some materials handed out as well for the judges. This is
we need to
a great learning
educate them.
experience for y'all, I'm sure, as much as it is for us. And if y'all could get a round of applause for Steve Cook.
First off, I'm just absolutely thrilled with the great turnout here. And I'm really thrilled to see a lot of new faces that we haven't seen before here. And we do these meetings the last Wednesday of every month here at Willie Ray's. So we hope that, this is not the last time we'll see you. The first time is and see some old faces that we haven't seen in a while. And I'm also thrilled that we have several judges
And to be
here
judges.
today. We have several judge-elects here today. We have a candidate that was the top vote getter in his race that is still got a race going on. And, it means a lot to me that you're here, and I know it means a lot to the group that you're here. And also all the interns and law clerks that are here. We're really thrilled that you're here as well, and hope that you'll have some fun. Now, what I'd like to do, I'd like to have some fun with this. So, I'd like to ask everybody to form into the teams, okay? And what I propose to do is we're going to go through this, and during the presentation, I'm going to be asking questions. And we'll let Matthew be the judge, but when you think you know the answer, raise your hand, and Matthew will call, and your team gets a point. At the end of the game, we'll give gift certificates out to the winning team. So there's skin in the game here if you're able to prevail. All right. So everybody's kind of naturally separated, so these are the teams, okay? All right, a couple rules about the game, though. If you guess wrong twice, you get a point deducted. And if the final question is going to be like Final Jeopardy, it will be worth 5 points. And so anyway, I'm going to start out by first asking this question. What is the basis that people are able, the legal basis that people are able to file Fourth Amendment motions in Georgia? What, Kim Fry? I'm looking specifically for the case law, statutory law, common law, what is it?
17 starts with 30.
So you made it multiple.
Okay, thank you. Well, who's got the answer? Steve Woodman.
OCGA 17-5-30.
Woodman team gets 1 point.
Where's your phone?
Okay, I'll try to speak up. I'll try to get over here so everybody can hear me. All right. And the bonus question for Steve Woodman's team. There's been a lot of discussion about this Utah case that came out last week and how the attenuation doctrine is now you have to see whether the officer's violation of constitutional standards was flagrant. Team Woodman, what argument does 17-5-30 present to Georgia residents that does not exist in, say, the Utah case?
Well, that statute
Speak up.
gives the citizens of Georgia greater protection than that afforded by the Fourth Amendment of the United States Constitution.
I'll give Woodman team credit for that. That's 2. Just to add to what Steve said, since Georgia is one of the only few states in the country to have codified a remedy in the elected representatives of codified 17-5-30, the statutory law has more teeth than a judicially created remedy, which is the way it is for federal law and for most states in the country. I did a bunch of research on this years ago, and Georgia was only one of a handful of states that had codified a remedy, okay?
Don't tell the sitting legislature that.
All right.
I don't mean anything.
Now, here's the next question. Women's team has two. Is there anywhere in Georgia law, case law or otherwise, that supports just what I just said, that OCGA 17-5-30 offers greater protections than federally created judicial statutes? Does anybody know where that exists? Does anybody know besides Steve Wooden? Does anybody know?
Is it the 24th section of evidence code?
No. That's an incorrect answer for Team Harris.
Thanks a lot. I'm in control with the judge, I just got here.
Matthew, if I could get your help here.
This two to
Keep it short, too.
Thanks a lot.
If we could just pass these out. The answer, since no one seems to know but Steve, Gary v. the State. Gary v. the State was a 1992 Supreme Court decision authored by Justice Robert Benham. And here's the next question. And I know you know the answer to this, see if anybody else knows. What was the significance in the trial level as to the Gary decision? What did it do? Does anybody know that? Gary.
There was a hand over there.
Gary. All right, what is it, Steve?
No, it wasn't Steve. Somebody behind him.
Judge Harris has his hand up.
Judge Harris.
Judge, Kim's got it.
You're right, but I'm looking for the specific application to the Gary case, the Gary suspect. Does anybody know that? Gary declined to apply the Leon good faith exception. Yep. Okay.
Judge Harris knew that.
That puts us back at even balance.
Judge Harris, just speak up.
No, they said Leon doesn't apply.
Okay.
They said the Leon.
All right, well, I'll give the team Harris a point. Okay.
That's enough for the judges.
Now, does anybody, based on what I said, how did Robert Benham, Justice Benham in the Supreme Court of Georgia come to that conclusion? Can anybody sort all this out?
Wise man.
Why did the Supreme Court say Leon good faith exception doesn't apply in Georgia? Anybody think about the process?
We're not quite that smart.
So it's judicially created.
Jill, you're on the right track, but you don't get credit.
That's our table apparently all the time.
What the Gary decision said was that the Leon good faith exception is something the Supreme Court of the United States came up with as a basis of a judicially created remedy. But since Georgia legislated, the citizens have enacted a statute that it provides greater protections. Jill, you want to appeal the answer there? Okay. All right. You're on the right track. But that's the basis, and that's how we are going to handle the district attorney's office to say, yeah, the officer just pulled somebody over to ID him, but it wasn't, wasn't flagrant. That's what Justice Thomas said, it's just negligence. He called the decisions of the police to do a fishing expedition negligence. And of course, he got called out on that in the dissent. But I mean, it was an intentional decision. They were just looking for information. And the Supreme Court said, well, that wasn't flagrant, so we're not going to apply the exclusionary rule, although everybody knows he didn't have probable cause to stop him. So, the way to when this decision trickles down to the prosecution ranks, and they will talk about it in Jekyll Island in a couple of weeks, how they're going to play this, way to combat that is to say, Your Honor, the Georgia citizens have enacted 7530. Georgia has more teeth. That's what our Supreme Court has said. That's what our citizens said. This business about flagrancy and so forth, Georgia citizens have more protections. And you will have solid legal footing to do that, okay? Has everybody got a handout? Okay. This is something I hope y'all all take home, you students. I hope this might, just be a little something you can add to your collection. But I've gone over essentially what I said on page 1. Okay? Now that we get to the kind of the grassroots of things, I'd like to ask Rick. Well, first let me say this. In my practice, it's a street level practice. I don't have white collar federal stuff. It's your basic man on the street issues. And over the years, there's 5 areas that I come across time and time again. Fourth Amendment, that the judges will see, the future judges will see. This is what you're going to encounter and what you do encounter. All right, the first is the casual encounter, Tier 1 versus Tier 2 argument. That's probably the number 1 issue that you see in the Superior Court and the State Court right now. Okay, number 2, Terry frisk, how it's executed. Number 3, prolonging traffic stops. Number 4, consent. That is often an overlooked one, but it is an important one. And 5, knock and talks. Now I'll say this much. Sam Langen and Jason Saliba, to their great credit, scored a major victory last year in the Court of Appeals, which overturned a case that they lost 7 years earlier, the Pando case. Pando has been overturned. And what the court said was that an officer, by mere smell of marijuana, can go and apply for a search warrant. Prior to this victory they had, the court said no, you had to have more than the smell, to get a search warrant. Okay? So now what that means is the officers don't have to be worried about talking their way in when somebody's at the door like they have been in the past. You always had, can I come in? Can I not come in? You have this, what happened? And you can win those. But now, since they don't have to worry about that, the knock and talk business is going to suffer a major decline because they just go get the search warrant when they have some problems getting in. So that really leaves the other 4. And to help illustrate this, I've asked Rick Kimberly to do a little walkthrough of first we're going to do a Terry frisk first, okay?
Uh-oh.
So here's the scenario.
Not like at the airport, though.
Here's the scenario. Rick is East Cobb dad. He's traveling down Johnson's Ferry Road about 2 o'clock in the afternoon. And Officer Cook of the Precinct 4 Cobb County Police initiates a traffic stop for a tail light. Okay? So I'm going to go through the scenario. And by the way, I do this when I do motions, a practice pointer. I do this in motions. I like to get the officers out in the well of the court and walk through these search procedures because when they're sitting down at the witness chair, it's easy to go through the sequence. But when you get them up and you ask them to explain it at the same time they're doing what they did, you're liable to get anything, okay? And you often do. So, Mr. Kimberly is pulled over on Johnson's Ferry Road at 2 o'clock in the afternoon for a taillight violation. And when you see a constitutional violation, hold up your hand, okay? All right. Mr. Kimberly, your license and insurance looks fine. I'd like to, just kind of show you the taillight problem. That you step out of your car just so I can show you what's wrong. Okay, that's the reason I pulled you over for this taillight violation. Now, would you mind if I got your permission to pat you down. I'm feeling a little bit, Jill,
Yeah, there's one there.
you think there is, or why do you think there is?
Because you gotta have a reason, you gotta have some sort of concern for your safety.
Jill Solomon has answered the question, but
Not for these cop
But, I will say this, if Mr. Kimberly consents to that, I think he's fine, okay? So let's move along a little bit more, okay?
Again, no point further.
Y'all are good.
All right. But good point, Jill. Mr. Kimberly, would you mind if I just kind of did a quick pat down? I'm a little concerned, here. Is it okay if I pat you down for weapons?
I'd rather not.
Well, I just would rather, do that, just so I can just sort of be okay with this. So that's when Jill's come in, okay? What would be the violation, Jill, at this point? He's denied consent.
I gave up.
He's denied consent.
Yeah.
What did Jill just say?
Concern for safety.
He's got to articulate a reasonable belief that Mr. Kimberly's armed and dangerous. Now, at this point, he's been completely cooperative. 2 o'clock of Johnson's Ferry Road. I mean, come on. All right. This officer, you get into, I search everybody's office policy. All that's no good. That gets your case thrown out right away, okay? There's a case in the handout that Judge Fincher addresses on that. Okay, Mr. Kimberly, just put your hands out and spread your legs here. This is a short pat down search for weapons.